Hi, this is Shar Wendell. I'm the President and CEO of Planned Parenthood of Collier County, and I have prepared this presentation today on Florida laws related to minors, a guide for Florida's Planned Parenthood affiliates. Please note that this is a confidential document and it's the property of Planned Parenthood of Collier County. However, permission is granted for use by all Planned Parenthood affiliates in Florida and their staff. As you all know, Planned Parenthood encourages parental involvement. Our waiting rooms are full of teens and their parents, but what about those that don't or can't involve their parents in their reproductive and sexual health care decisions? Well, that's what today's presentation is about, Florida laws. We're going to be talking today about the provision of family planning services to minors, testing and treatment of STIs, and the mandatory reporting of child abuse within our health centers. We'll be reviewing the Florida statutes, and just for you to know, the Florida statutes can be found on the Florida Legislature's website, and I've given you the link right here. However, if you cannot remember the link, it can easily be found through myflorida.gov. And in fact, as you're driving around the streets of Florida, you'll notice that the license plates in front of you all have myflorida.gov, which is the state of Florida's portal. We're going to be talking about family planning services, particularly about Florida Statute 381.00515A. Under this statute, 381.00515A, maternal health and contraceptive information and services of a non-surgical nature may be rendered to any minor, providing the minor meets one of the following requirements. 1, she's married. 2, she's a parent. 3, she's pregnant. 4, she has the consent of a parent or legal guardian. Or 5, may, in the opinion of the physician, suffer probable health hazards if such services are not provided. Now, please note here that Florida Statute 381.00515B specifically delineates for us that the application of a non-permanent internal contraceptive device is not deemed a surgical procedure. A suggested procedure is that you place a note in each minor's family planning chart which indicates the provision of law that applies that you are using to treat this patient. And in fact, at Planned Parenthood of Collier County, we have the statute actually printed in our history sheet, and the nurse practitioner checks off the specific provision that applies for that patient. Obviously, in addition to providing family planning to minors on a regular basis, we also provide treatment and testing for STIs. Florida statute has a chapter referred to sexually transmissible diseases, and under section 384.30, we find the law that allows us to provide services to minors without parental consent. Under section 384.30, the consent of the parents or guardians of a minor is not a prerequisite for an examination or treatment. And you'll note that unlike the family planning law, there is no specific requirements to determine whether or not a minor can receive testing and treatment for sexually transmitted diseases. In fact, just the fact that she's a minor or he's a minor seeking services is enough to fulfill the requirements of the law. In fact, the Florida legislature is so concerned about minors being able to receive testing and treatment that they even have a provision in the law, 384.302, that says that the fact of consultation, examination, and treatment of a minor for an STD is confidential and shall not be divulged in any direct or indirect manner, such as sending a bill for services rendered to a parent or guardian. Now let's talk about mandatory reporting of child abuse. We are mandatory reporters, and we'll talk about what that means in a second. And the two laws that we'll be referring to right now are Florida Statute 39.201 and Florida Statute 827.04, subsection 3. And you see I have the vision here. The vision, Florida's highest priority is that children are raised in a healthy, safe, stable, and nurturing family environments. And in fact, that is a poster that you'll find linked on the Florida Department of Children and Families. Florida Statute 39.201(1)A mandates that any person who knows or has reasonable cause to suspect that a child is abused, neglected, or abandoned by a parent, legal guardian, caregiver, or other person responsible for the child's welfare shall immediately report such knowledge or suspicion to the Florida Abuse Hotline of the Department of Children and Families. Now please note the emphasis has been added by me to point out that we're looking for abuse by a parent, legal custodian, caregiver, or other person responsible for the child's welfare. Now you're probably wondering, as a staff person of Planned Parenthood, are we mandated reporters? Well, let me point out that this law says that any person that knows or has reasonable cause to suspect shall immediately report. So basically, everyone that lives in Florida is a mandated reporter for child abuse. However, you are a mandatory reporter and a special mandatory reporter, meaning that under a different law, 39.2011B, all staff at Planned Parenthood that makes a report to the Department of Children and Families is required to give his or her name to the abuse hotline when making the report. Now note, your name will be entered into the record of the report, but it is held confidential except as provided by specific laws. So although every person in the state is a mandated reporter, every person has the requirement, the legal duty to report suspected abuse or neglect, only some people under Florida law are required to give their name to the Florida Abuse Hotline of the Department of Children and Families, and that's all of you that's watching this presentation today. Not only are you a mandated reporter, but you'll be required to give your name. As a mandated reporter, you're only required to notify the state of abuse, again to reiterate, when the offender is the victim's parent, legal custodian, caregiver, or other person responsible for the child's welfare. Again, you're only required to report if the victim is being abused by their parent, a legal custodian, a caregiver, or another person responsible for the welfare of the child. Let me say it again. We are required to report child abuse. The law in Florida is very clear that it requires that we report child abuse as it is defined in Chapter 39 of the Florida statutes. And again, as is defined, as is if the offender is the parent, guardian, caretaker, or someone else responsible for the welfare of the child. Now there is one addition to the definition of child abuse in Florida law, and that can be found in Florida Statute 82704, which is a statute entitled Contributing to the Delinquency or Dependency of a Child. This law specifically was passed by the Florida legislature to deal with what the legislature saw as the increasing problem of teen pregnancy when a minor was impregnated by an adult. And this law, 82704, subsection 3, states that a person 21 years or older who impregnates a child under 16 years of age commits an act of child abuse. And that's my emphasis added again. But no, a person 21 years of age or older who impregnates a child 16 years of age or younger, impregnates a child under 16 years of age, commits an act of child abuse. And this act of child abuse is considered a felony of the third degree. And no, neither the victim's consent or the victim's lack of chastity is a defense to the crime, which basically means that this is a statutory rape law. It does not matter whether or not the victim consented, or has no bearing whether the chastity of the victim was prior to the impregnation. Now, under the law, as we've already discussed, under the law, Chapter 39, we are required to report child abuse in the situations that we've already highlighted. However, with this exception, you'll see that under 39.2012D, if the report is of an instance of known or suspected child abuse, involving the impregnation of a child under 16 of age by a person 21 years of age or older, the report shall be made immediately to the county sheriff's office or other appropriate law enforcement agency. If the report is of an instance of known or suspected child abuse solely under this section, the reporting provisions of this subsection do not apply to healthcare professionals or other persons who provide medical or counseling services to pregnant children when such reporting would interfere with the provision of medical services. And again, this is my emphasis added with the purple. However, to state again, what this law is saying is that all child abuse must be reported, as we've already just defined it. In addition, what needs to be reported is any known or suspected abuse that relates to a girl under the age of 16 who has been made pregnant by a person 21 years or older. There is an exception, though. It doesn't automatically mean we must report. We can determine that we will not have to report if we determine that such reporting would interfere with the provision of medical services. A suggested procedure would be that in every case, a determination must be made that involves a pregnant girl under the age of 17 when Planned Parenthood knows or suspects that she has been impregnated by a man 21 years old or older if reporting the crime would interfere with the provision of medical services. This determination must be properly documented in the patient's chart and should be made in consultation with the medical director or his or her designee. So to clarify, we are required in Florida law to report any known or suspected incident of a girl under the age of 16 who is pregnant and the father is a man who is 21 years old or older. We are required to report that unless we make a determination that by reporting that to law enforcement, it would interfere with us providing medical services. And I would suggest that this documentation, this determination, should be documented properly in the patient's chart as we document everything that we do, and that the initial determination of whether or not we will choose not to report should be made in consultation with the medical director or his or her designee. In summary, we need to report child abuse, and I've given you the hotline number here. The hotline number is 1-800-96-ABUSE, but you can also make a report online. So I would suggest that information on reporting will be provided to all staff and will also be easily accessed in each health center, the methods and procedures of how to report child abuse. Remember, we always prefer and encourage parental involvement, but Florida laws allows Planned Parenthood to provide minors family planning services if a teen is married, a parent, pregnant, has the consent of a parent or legal guardian, or may, in the opinion of the physician, suffer probable health hazards if such services are not provided. We can also provide the examination and treatment of sexually transmissible infections without parental consent. And we are required to report child abuse as defined by the laws discussed in this presentation.